Yes, ladies and gentlemen, it is both a privilege and an honor to be the moderator of this panel, which focuses on the future and the challenges and innovations for modern advocacy, bar association, and courts in light of the emerging impact of AI. The general theme of the subject is safeguarding democracy, rule of law, and justice, global challenges, and the role of AI. Over the past few days, other panels have focused on various other aspects of AI. Our panel has a different focus that is more centered on the future of our profession, our representative bodies, and above all, the courts that ultimately determine our modus operandi. Our panel consists of distinguished judges, scholars, and practitioners. With their permission, I will take just a few moments to introduce each one of them. Their CVs are available on the website of the summit, and the detailed presentation would take a large part of our limited time. I will begin with the Honourable Justice of the Federal Court of Australia, Dr. Melissa Anna Perry, who also serves as the Deputy President of the Defence Force Discipline Appeal Tribunal, holding the rank of Air Commodore as well. Impressively, she obtained a PhD in Public International Law from the University of Cambridge. She's been Queen's Counsel since 2004 and member of the Inner Temple after being admitted to the Bar of England and Wales in 2012, among many other qualifications. We shall begin with her presentations on the challenges of AI to the judiciary and courts, and shall continue with Mrs. Niovi Christopoulou, who's an experienced corporate attorney, admitted in New York, Washington, and Athens, an investor and thought leader focused on AI, and an adjunct professor in business law at the City University of New York. Niovi is currently a partner at AI.Fund, a Hamburg-based venture capital firm investing in AI and digital technologies. In the past, she led strategy for Amazon fintech innovation globally and practiced an M&A law at international firms in New York and Washington, D.C. And Niovi is the first US-based candidate in the recent European Parliament elections. Next, we have Dr. Christos Papastylianos, a distinguished Greek constitutional scholar and associate professor at the University of Nicosia Law School, holding a PhD from the European University Institute of Florence, and who is a prominent contributor to the legal reform debates in Greece and Cyprus. He will focus on the protection of constitutional and civil rights through checks and balances in the use of AI. So we shall, I'm sorry, I didn't mention Mr. Nicholas Tsardellis, who is the Vice President of the Cyprus Bar Association and partner at Elias Neocleous and Company, LLC. He leads the litigation and dispute resolution department of the firm and is widely recognized for his expertise in cross-border disputes, commercial litigation, and white-collar crime. As Vice President of the Cyprus Bar Association, he plays a key role in shaping the future of the legal profession in Cyprus, and we as Greek lawyers would expect to listen to ideas and advice to upgrade the role and status of our own Bar Association. We shall start with the Honourable Justice of the Federal Court of Australia, Dr. Melissa Ann Perry.
Thank you very much indeed, and thank you to everybody who has stayed through to the bitter end. It's greatly appreciated, and I hope that there'll be some value and insights coming from this eminent panel. In the movie Eye in the Sky, starring Helen Mirren, senior military personnel from the British and US authorities were advised, after much debate, that it was lawful under international humanitarian law to order an attack by a drone on a cell about to exercise a suicide bombing with multiple deaths predicted. Collateral damage being the likely killing of a little girl who was selling her mother's bread from a makeshift stall proximate to the attack, was considered proportionate to the harm that would be caused if the suicide bombing were to proceed. However, the agent on the ground was moved by the little girl's plight, and with barely a moment to spare, he acted to save her by bribing a local child to buy the last of the little girl's loaves in the hope that she would leave before the assault. This example illustrates how the exercise of discretion by a human decision maker may mean achieving not merely a lawful result, but one which better accords with the fundamental human values of mercy, fairness, and compassion in the individual's interest and in the public interest. It also illustrates the ability of humans to problem solve in creative and imaginative ways. Such fundamental human qualities as mercy, compassion, and fairness draw upon our shared understanding of the frailty of the human condition and lie at the core of our common humanity, resonating through the ages, across cultures, and underpinning fundamental human rights. Human qualities of the kind to which I've referred have long informed courts and government decision makers in the exercise of discretions. While the width of statutory discretions will vary according to context, discretions potentially afford us as humans the latitude to make judgments and reach decisions which reflect community, administrative, and international values and align with statutory objects in the face of a wide or almost infinite variety of individual human circumstances. However, these are qualities utterly lacking in any machine technologies. No robot has yet been created with a conscience, let alone the capacity for sentience, understanding, or independent thought, or indeed common sense. Thus, while generative AI can emulate the process of exercising a discretion, and it may give reasons which give the appearance that it is exercised a discretion or engaged in an evaluative process, it's no more than smoke and mirrors. Nor are other forms of technology, such as machine learning, capable of exercising discretions. This leads me to a concern which I have long held, that the massive efficiencies and cost savings which the use of machine technologies potentially afford in government decision-making may encourage governments to frame laws in such a way as to authorise and facilitate the use of technologies by requiring the application of strict rules and thereby erode the scope and number of discretions vested in administrative decision makers, whose decisions we as judges ultimately adjudicate upon. Those concerns are heightened in the context of decisions which affect human rights and interests. Even the use of such programs to assist in the exercise of discretion should be approached with caution to ensure that the human decision maker brings a properly independent mind to bear upon the issues and interrogates the data provided by such technologies. An example of the kind of technologies that we've been talking about through the course of this Congress, and about which much has already been said, is one form of generative AI, being a large language model or LLM like ChatGPT, Copilot, Claude, Grok, Google Bard. An LLM, of course, is a complex algorithm which responds to human prompts to generate new text representing the most likely words and the most likely word order based on training from massive data sets. The text, therefore, is the product of nothing more than probabilities. I sometimes describe it as effectively predictive text on steroids. The manner in which generative AI functions has a number of consequences which are also highly pertinent when consideration is being given to the use of such models in the judicial and litigation spheres. And of course, we are seeing these technologies being embedded in many of the programs that we use to undertake legal research, as well as more general research and more across the border. I'm not going to attempt to cover all the consequences, and I suspect that you wouldn't all thank me if I did. And many of these have already been brought out in presentations at this Congress. But what I want to do is highlight 4 short points, which, as I've said, I think are pertinent to all of us in the legal profession and as judges. First, the risk of hidden bias influencing outcomes from generative AI isn't merely because the data on which it's trained is historical, which will contain all of our previous prejudices and discrimination and from earlier decisions. Because generative AI operates by formulating the most likely sequence of words in the most likely words in the most likely sequence of words, it may limit exposure to a range of different and competing views, particularly minority opinions, and further marginalise minority and disadvantaged groups in response to prompts. As the Consultative Council of European Judges recently opined, technology isn't design neutral. It carries the inherent risk of discriminatory design, implementation, and use. Design may discriminate against parties on the grounds of race, ethnicity, sex, or gender. So while we all tend to think of machines as being objective and far more objective than us, it's just simply not the case. And this is one of the things that we need to bear in mind when we use these technologies. Secondly, the outputs of an LLM are unpredictable. Devoid of understanding or concepts of accuracy, the capacity of LLMs to hallucinate or make up information and to convey these hallucinations convincingly is well documented. And reference has already been made in other papers in the course of this Congress to examples in litigation of fake case citations generated by AI on which parties have relied to their peril. Added to this, the way in which outputs have been generated by an LLM are also generally unknown and unknowable, even by their developers and programmers. So in other words, the systems operate, as they're often described, as black boxes, having completely opaque decision-making processes. So not only is reliability of output a significant issue, but the use of LLMs raises serious transparency, accountability, accuracy, and therefore audit and reliability issues. But the metaphor of a black box is also apposite in another respect. Given the incapacity of LLMs to think outside the box, as per my first example, or even within the box. And an example of the latter is given in a collaborative paper published last year by researchers from eminent universities in the United States and the UK, as well as the UK AI Safety Institute and Apollo Research. This exposed what the authors described as a surprising failure of generalization in autoregressive large language models. If, in other words, a model is trained on a sentence of the form A is B, it will not automatically generalize to the reverse direction, that is, that B is A. Thirdly, the inability to differentiate between human-generated original source data and data generated by LLMs in the process of training LLMs may exacerbate these issues. So research published in Nature last year showed that data generated by LLMs contaminated the training set of data for the next generation of LLMs with its biases and hallucinations. So they gave an example of an original input about European architecture in the Middle Ages, a subject of some considerable seriousness and learning. But by the 9th generation, the LLM produced nonsense about multicoloured jackrabbits. So this illustrates the potential for model collapse, with the original data on which the LLMs were trained being effectively lost. The final point I would make is one that's been emphasised by a number of the very eminent speakers from whom we've heard during the last few days. And this is a subject on which I feel very passionately. That is that it is not just the outcome that matters. AI may give the same answer which a human decision would give. And it may be able to give it more efficiently and more quickly. And this may seem very, very useful, especially to all of us who are under pressure to make decisions in short time frames. It may also give the answer drawing on a large body of knowledge, a much larger body of knowledge than we are even capable of comprehending. But the process matters to those whose lives are affected by the decisions which we as judicial officers make. The fact that the reasons given for the outcome are the product of a human being who listened and considered the evidence and the submissions and brought to bear human qualities of the kind to which I referred at the start today upon their decision also matters. And this view isn't merely based on my own experience as a judge of almost 13 years now. Studies based on interviews with litigants show that confidence in the system depends upon the litigant feeling that they've been heard, and not necessarily just upon the outcome. For example, a consultation report prepared in 2016 for the Australian Judicial Council on Cultural Diversity, considering migrant and refugee women's experience of the court, highlighted the importance of the courtroom experience for those litigants for promoting access to justice and building confidence in courts. That report found that a negative experience at court may not only impact on a woman's recovery from trauma, but it may have a broader impact within the community. For example, many women whose experience was negative would take that message back to the other women in their community, telling them that the legal system can't help them and in fact may cause them more trouble. But conversely and positively, the report found that women's satisfaction with court processes in the majority of cases was intricately linked to how accessible court and court processes were, how they were treated, and whether they felt like they had been heard. So in our excitement in taking up these new technologies, it's also really important to understand what the limitations are and what the nature of the applications are. And it is also important never to lose sight of the critical role that fundamental human values and qualities bring to bear on decision-making. Thank you.
Thank you very much. There is food for thought, and we shall come back with the questions, I understand. Now the floor is with Niovi.
Thank you. Thank you.
On a more general subject.
Thank you very much. Thank you the President of the Advocate Association for hosting this pioneering summit. And of course, to our fellow Christos lawyers and the chairman of AIandLaw for inviting me, giving me the opportunity to Oh, right. Okay, I was using the wrong.
Close and close.
Yeah, we're closing that. Thank you. So I was stating that I was prepared to discuss the use of AI by big law firms in the US, where interesting things are happening. And very recently, big law firm partners are becoming investors in their own legal text
even coming up with products that can predict the exact pattern of thinking and decision-making of judges, for example. Is very interesting, very exciting, and there are tools to assess risks in an M&A transaction pertaining to the target company. It's a very technical and very interesting discussion, and anybody who's interested in details, please feel free to contact me, because I thought being on the ground instead, and seeing the urgency of the geopolitical context of AI and what it means for our sovereignty, national security, and digital and AI sovereignty, I thought it would be more timely to discuss AI's geopolitical imprint and Greece's opportunity within a regional partnership in the region of the East Mediterranean. We can't really discuss about rule of law or democracy or national sovereignty without taking into account digital sovereignty, which requires in turn a foothold in AI infrastructure so that one can be a stakeholder in this big global tech game of civil rights and business opportunities, and also of data sovereignty. And this architecture of a proposed AI strategy in turn should be reflected, and going back to the topic of the discussion, should be reflected by very targeted, intentional initiatives by the bar associations and by the legal profession. It's most important that the legal profession stays on top of this evolving matter, however challenging it is to catch up with tech. I think it's a great opportunity for all of us to become a little bit of engineers and dive deep and have a more de facto approach to law and a proactive stance, because the pace of development is like unbelievable. So by 2030, AI will be contributing $15 trillion to the global GDP, 1 trillion of which will be invested in AI infrastructure in the US, and another trillion globally. However, this wealth will not be accessed equitably, and it will be accessed disproportionately by nations and regions that manage to have like strengths in talent and capital and data frameworks. What would be the right strategy in this framework to ensure a place for Greece in the region so that it's not left outside of the loop in a landscape of large language models that ignore totally Greek language? So there goes the discussion around legal documents and the court system, right? We don't even have adequately trained AI models in Greek language. And in a new emerging landscape where big tech is really pulling its weight. I believe that there's an opportunity for Greece to engage in a partnership and maybe update the recently much talked about partnership of 3+1. I don't know if you've heard about it. It's geopolitical, and it pertains to the discussion of cybersecurity cooperation and maritime security cooperation, involving the three nations of Greece, Cyprus, and Israel as a regional partnership with the United States of America. So why not reposition this partnership to ensure that the region can also be a tech innovation corridor, also including issues of cybersecurity and AI development. Building a partnership like that, we should take into account the unique strengths of each country, because I know like many people are pessimistic and very eager to give up, especially on Greece's opportunity to participate in this dialogue. So Israel apparently is the leader in tech and venture capital investment in tech. Cyprus is a financial and regulatory gateway, and is very pioneering in putting together regulatory sandboxes. I know about Cyprus's sandbox pertaining to fintech, for example. Greece, in turn, is a NATO and a European Union member state, and most importantly, it's a very trusted ally, according to the State Department of the United States. Within the EU, Greece was selected to develop one of the 7 AI factories. It's called Pharos, and it will be positioned as an EU-level AI innovation hub from Greece, focusing on green AI, ethics, and also AI for small and medium enterprises, something that I know is like fuels the blood of the Greek economy, and it's probably like 90 or over 90% of Greek economy, and probably represents a big clientele of yours and of your endolees. Also, it hosts a supercomputer, Daedalus. It's a supercomputer exceeding like 60 petaflops. This is like an up to 50 million euro project. It will serve as a backbone for AI within the EU and specifically within the region. And Pharos will be used to host EU-level AI training hub. And I think it's very important that they both comply and that they both tie into EU's Gaia X, which is EU's project for sovereign data, connecting cloud service provider with cloud users and ensuring federated learning of AI models, which in plain language means basically that you can keep your data local, which is very important, and yet benefit from the training of AI models. And I consider this like very strategic for Greece and for smaller countries and for countries with languages that are not English. Therefore, to ensure that we can discuss about AI sovereignty, we need to address AI infrastructure, which includes development of data centers. You may have heard of all these big hyperscaler agreements that were entered into in Greece with the Greek government. Energy, which is also like a very key topic, energy connectivity, adequate supply of semiconductors, another business issue that now has many legal implications and geopolitical implications. Second, we need, of course, to have the right talent and the right mix of talent and capital. And whoever has worked with big tech companies knows that Greece has an amazing reputation in terms of talent. Top-notch engineers that big tech companies are really competing to hire and recruit. Third, and very important, especially for a legal audience, is high-quality, localized data with data governance and federated AI models. I think that this is a great opportunity for bar associations and for the legal profession to become a stakeholder with a seat at the table, because data is not only AI's fuel, but it also has implications for sovereignty, going all the way like from personal data and what big tech does with it to national security data. Just to give you an example, NATO's data is hosted on IBM's cloud. So a multilateral security organization trusts all of this sensitive data on the cloud of a US big tech company. High quality, verifiable data can build relationships of trust around AI. I want to emphasize again for Greece specifically the importance of small language models, models trained with first-party data so that you can keep it at a smaller scale and you can keep it local, and federated learning AI models, as well as potentially quality synthetic data so that we don't have to be entirely dependent on LLMs and the big tech ecosystem. These are all essential for Greece. As well as the proper data governance frameworks. And I think there's a lot of room there for legal innovation and legal engineering. And there have been a lot of talks also at the EU level recently around revamping some of the GDPR provisions, because the EU is feeling the pressure, right, from the other global tech economies. And there's this interesting opportunity of matching a little bit the pace of regulation to what's going on in the tech world. So Greece could serve as a trusted regional data host with GDPR-aligned cloud and lead potentially a Mediterranean data localization initiative. This could all be very doable if there's awareness, especially in the legal community around it. It's very important that Greece can offer EU-compliant data and can utilize and can leverage its position and whatever existing tech it has. And very important also, again, for the legal profession to participate and embrace these technologies so that it can actually develop strategies and proposals around it. The fourth element is AI diffusion, right? Like the adoption of AI through verticals that reflect a region's unique challenges and know-how, such as maritime security, bioclimate challenges, migration, the flows of migrants. This is like something unique potentially to Greece and very sensitive and interesting data that should be leveraged. Also agri-tech and green tech. Let me highlight especially with regard to maritime AI, how timely this is for Greece, because it pertains to security, as well as port logistics, and predictive analytics for maintenance of LNG terminals. We'll be hearing a lot about business interests and geopolitical discussion around these areas. Furthermore, let me suggest that this alliance of partnership of 3+1 should definitely include the EU. The Commission recently released its EU AI Continent Action Plan, earmarking 200 billion euro for the development of European large language models, also to compete globally for tech talent and to ensure the flow of talent throughout the EU. And also another side note that shows the nervousness and the challenge for regulation to catch up with all of this. The Commission also announced that potentially freezing the applicability of the provisions of the EU AI Act around high-risk applications of AI, and it opened actually public consultation showing an interesting hesitation around the implementation of its regulatory initiative and the much talked about Brussels effect. Right now, the Brussels effect is a little bit on hold, right? Because there's so much happening in the world. To give you a quick perspective between the EU and the EU, in the US, there's no real federal regulation around AI. It's mostly addressed through verticals and sectors. And the approach, I'm generalizing here, but I think it's interesting. The approach is one of product liability for the most part that involves really Byzantine certifications around specs. So that's how the US has been handling this so far. The new administration rescinded the previous administration's executive order around development of safe AI. So that shows definitely a policy shift that's going to be reflected in regulations and the legal framework around AI, prioritizing US development of AI and national security. And what is a very interesting wrinkle is that you must have all heard about the big, beautiful bill that just passed in the Senate. There was a very intense negotiation around a proposed freeze, a 5-year ban on the state's regulatory initiative on AI matters. That's very important because the states in the US are considered the laboratories of democracy, and they tend to have a more anthropocentric approach to AI, right? Less profit-centric. However, interestingly enough, this was turned down in the negotiations that took place in the Senate, and now the states are able to regulate. I predict that there will be a federal preemption at the level of AI model training, and probably at the level of AI use and deployment. The states will have a lot of leeway for regulatory activity. With some interesting extraterritorial effects, especially coming from California, where some of the big tech is headquartered. I don't know if you see where I'm going with this, but it's like an interesting conundrum of EU laws trickling down to national laws, right? And US federal regulations and state regulations with geopolitics at the heart. And an interesting universe where absolutely the legal profession needs to claim its place, needs to innovate and advocate really for rule of law, for the importance of human supervision, for the importance of the human judge and the legal system, because I don't think it's going to be granted by 2030 when everybody's talking about AI singularity. So these are my thoughts. Thank you. Thank you very much for having me with you today.
Thank you very much. This is a lot of information. It has to do also mainly with the 3+1 and the state activities. It can affect the Bar Association, but if we want to see how the everyday life of lawyers is going to be affected, we should go perhaps a step lower, and perhaps this is what Mr. Tsardellis is going to describe with his experience in the Cyprus Bar Association and also with his personal interest in promoting the role of lawyers and advocacy.
Καλό μεσημέρι, ευχαριστώ κύριε Μπερνιτσά. Ευχαριστώ όλους σας για την υπομονή σας, τρίτη μέρα του συνεδρίου. Ευχαριστούμε όλοι οι ομιλητές εδώ που είχατε την υπομονή να μείνετε μέχρι σήμερα, τελευταίο πάνελ. Θα μου επιτρέψετε με την ευκαιρία της ολοκλήρωσης του σημερινού συνεδρίου να ευχαριστήσω ιδιαίτερα εκ μέρους του Παγκυπρίου Δικηγορικού Συλλόγου, ιδιαίτερα τον κύριο Βερβεσό, ο οποίος είναι απασχολημένος με το θέμα του. Κύριε Βερβεσέ, να σας ευχαριστήσουμε πάρα πολύ για τη διοργάνωση αυτού του συνεδρίου, για τη φιλοξενία, για την εξαιρετική διοργάνωση. Η ιδέα του συνεδρίου αυτού ήταν δική σας. Δείξατε αφοσίωση, ούτως ώστε να πραγματοποιηθεί και ελπίζω να γίνει θεσμός και να παραλαμβάνετε κάθε χρόνο. Ελπίζω του χρόνου σε κανένα νησάκι έτσι λίγο πιο χαλαρή. Ή στην Κύπρο, ή στην Κύπρο. Στο συνέδριο αυτό ακούσαμε τις τελευταίες 3 ημέρες. Στο συνέδριο αυτό τις τελευταίες 3 ημέρες ακούσαμε να μιλάνε αγγλικά, ελληνικά, σκέφτηκα να μιλήσω και εγώ λίγο κυπριακά, να ακούσετε και τη δική μας διάλεκτο, αλλά νομίζω θα δυσκολευτούν πάρα πολύ. Θα δυσκολευτούν οι μεταφραστές μας, οπότε θα συνεχίσω την παρουσίαση μου στα αγγλικά και ίσως επανέλθω αργότερα λίγο με ελληνικά και κυπριακά. Today, I'm not speaking as a practicing lawyer, but from the perspective of someone serving on the board of a bar association. That lens brings a broader strategic view focused on institutional values and the long-term impact on our profession and society. Let me start by saying clearly, AI offers, of course, many advantages for the legal community and for the public. Improved access to justice, more efficient procedures, enhanced legal research, greater speed, and much more. At the same time, we hear a lot at conferences like this about the challenges: fairness, accountability, bias and discrimination, lack of transparency, concerns around confidentiality. These are real and serious concerns. Bar associations, without a doubt, have a duty to raise awareness, provide training, and guide our members ethically and practically as they adapt to new tools and realities. But since many of these challenges have likely already been covered or are frequently discussed, I would like to take a slightly different approach. I want to focus on 3 deeper institutional challenges, ones that speak to the future of our profession itself. The first challenge is pace. Quite simply, the speed at which AI tools are evolving has already outpaced our ability to assess, regulate, and respond. A few years ago, we knew AI would shape the future of the legal profession. National bars, as well as our international and European associations, began developing principles and raising ethical concerns. But the technology moved faster than we could. It became impossible to evaluate every new tool, predict every risk, and publish tailored guidance in real time. In the end, much of what we have published has focused on broad values: transparency, accountability, and human oversight. These principles are very important and relevant regardless of new releases of an AI model or software tool. But the question is, are they enough? Just in the past year, we have seen an explosion of new capabilities: GPT-4, AI-powered litigation tools, autonomous legal agents, even pilot projects involving robot judges. These are no longer hypothetical. They are here and being used. So the question is, can high-level principles alone guide the responsible use of tools that are changing monthly, sometimes weekly? In my view, they cannot. Each use case demands specific scrutiny, and each new tool presents different risks. Yet, our institutional response structures, as they exist now, are slow by design. We rely on long consultations, layers of review, and broad consensus. That's good for legitimacy, but it's too slow for what we are facing. And that delay creates a vacuum. Practitioners are left to navigate these new tools without clear guidance. And so, what can we do? Perhaps it's time to ask whether we need more agile structures within our institutions, the bar associations, dedicated task forces or expert panels that can issue interim guidance on emerging tools, structures that can move quickly without needing full board approval each time. But that, of course, raises a harder question. Are we prepared to delegate authority in moments of urgency such as this? Can we trust certain members or advisors to act on behalf of the wider body when speed is critical? That's not a small shift. It's a question of institutional culture and trust. The reality is we cannot predict every future AI tool, and we certainly can't make any final decisions today about tools that don't yet exist. But we can start building institutions that are not just responsible, but responsive, designed not only for stability, but for adaptability. And maybe that's the most important change we need to make. The second challenge I'm going to talk about is inequality. Inequality not just between clients, but within the legal profession itself. Legal systems have always varied. Some countries are highly digitalized and efficient. Others still rely heavily on paper. Also, procedural rules differ, and some jurisdictions struggle with outdated systems and long delays. These disparities are not new, but AI changes the nature and the scale of that disparity. With AI, we're not just talking about who has faster computers or procedural regulations. We are talking about entirely different ways of practicing law: automated contract drafting, predictive litigation analytics, even AI-assisted judicial decisions. These are not upgrades, they are transformations. And the problem is, not every bar association, not every country, not every firm has the resources or the expertise to implement them. The risk here is clear, in my view. We could end up with two versions of the legal profession. In one country, lawyers working alongside AI co-counsel, in another practicing much the way they did in the 1970s. It's like having two different species of lawyers. And for me, that's deeply troubling, because despite our many differences, lawyers around the world have always shared something fundamental: a common professional identity. And if that shared identity breaks down, if AI creates two legal words, we don't just lose equality of access, we lose our ability to act collectively, to speak with a united voice when it matters. And that's a big problem, in my view. Finally, very briefly, I want to speak about identity and what we risk losing if we are not careful. AI can and should support our work, but it must remain a tool, not a substitute. Law is not just about efficiency or correct answers. It's about human interaction and dignity, about hearing someone's story, about interpreting complexity in a way that technology cannot. If we allow AI to become not just a tool, but the interface, if lawyers and judges are replaced by automated systems, we may gain speed, but we lose something far more valuable, the integrity and trust at the heart of the legal system. That's why bar associations must defend the human character of our profession, not because we're anti-technology, not because we fear change, but because justice demands more than data. It requires presence, its connection, and justice without the human element is not justice, it's only decision-making. Thank you very much.
Thank you very much, Mr. Tsardellis. That was, let's say, a very interesting introduction, and we shall come back to that. And perhaps if we have some time to ask questions, we should revert and ask what would be the impact on every one of us and how the bar associations can, let's say, upgrade the services they offer in order to sort of benefit to those who are perhaps already in the second tier, because you said something about, let's say, two different categories of countries or bar associations or law firms. And sometimes I'm afraid that this dichotomy exists already. So perhaps it is high time to do something in order to remedy this situation. Now, last but not least will be our speaker, the distinguished Greek constitutional scholar, Mr. Papastylianos, who is going to give us, let's say, tell us more about the checks and balances that we need to have and the various concerns that arise from AI.
Σας ευχαριστώ πολύ. Ευχαριστώ πολύ τους διοργανωτές του συνεδρίου για την πρόσκληση. Παρακολούθησα και κάποιες άλλες συνεδρίες. Θεωρώ ότι οι συνεδρία τα οποία φέρνουν σε επαφή ακαδημαϊκούς αλλά και δικηγόρους της πράξης έχουν να προσφέρουν πάρα πολλά. Δηλαδή, από τις σημερινές συνεδρίες, προσωπικά θεωρώ ότι εάν αρχίσει μια συζήτηση και λυθεί το θέμα της διπλής φορολόγησης με την Αυστραλία, θα είναι κέρδος για το συνέδριο. Θα είναι ένα από τα κέρδη του συνεδρίου. Συνεπώς, θεωρώ πάρα πολύ ενδιαφέρον και το συνέδριο και την διοργάνωση και το σκεπτικό πίσω από την διοργάνωση αυτή. Θα μιλήσω στα αγγλικά γιατί έτσι είχα ενημερωθεί, έχω δώσει όμως το κείμενο και άρα μπορεί να γίνεται αυτόματη μετάφραση. Το θέμα με το οποίο θα ασχοληθώ είναι η σχέση της τεχνητής νοημοσύνης με τα δικαιώματα. Anyone speaking about artificial intelligence and human rights confronts two major challenges. The one is the impact of artificial intelligence to human rights. The second one is whether or not artificial intelligence can be considered as a holder of rights. There is no straightforward consensus definition on artificial intelligence. However, there is a common ground. Artificial intelligence is best understood as a set of techniques aimed at approximating some aspects of human or animal cognition using machines. Thus, artificial intelligence can adversely affect the liberty and justice of individuals, particularly when implemented in high-impact contexts, such as criminal justice. The complexity and opacity of AI systems may interfere with the rights to a fair trial, including the right to equality of arms, in which a party subject to an algorithmic decision can adequately examine and contest their reasonings. Artificial intelligence can access enormous amounts of data of individuals and process it with incredible speed. Artificial intelligence can make predictions about a person's behavior, state of mind, identity, by sensing informations that are not necessarily considered as personal or private data, such as facial expressions, heart rate, physical location. Artificial intelligence affects also equality and non-discrimination. Artificial intelligence systems are capable of reproducing and augmenting the patterns of discriminatory treatment that exists in society in which they are created. The automation of both eligibility, determination, and allocation of government benefits can create more efficient service delivery, but can also leave those denied benefits without recourse, or leave them to navigate complex forms or other processes without compassionate assistance. The Council of Europe provided some recommendations on this issue. According to these recommendations, there should be principles and priorities for a legal framework for regulating artificial intelligence. The principles and priorities such a legal framework should include concerns about the impact of artificial intelligence on human dignity. Humans should be treated as moral subjects and not as objects to be algorithmically scored or manipulated. Human freedom and autonomy. These systems should not be employed to condition or control humans. Prevention of harm. IA systems must not be permitted to adversely impact human well-being or planetary health. Non-discrimination. AI systems must be designed to be fair, equitable, and inclusive in their beneficial impacts. Transparency. Meaningful information about the rationale underlying its outputs must likewise be provided. Data protection. Informed, freely given, and ambiguous consent must play a role in this. Accountability and responsibility. Those who are negatively impacted must have access to effective remedy to redress harms. Rule of law. To ensure this, the transparency, integrity, and fairness of the data and data process methods must be secured. However, such recommendations are useful, but they do not cover the whole range of issues which are relevant to artificial intelligence and human rights. The broader issue related to artificial intelligence and human rights is the following. Is the question of how to design systems that make or help make consequential decisions about people. There are three distinct facets to a thorough exploration of the role of IA systems in consequential decision-making. The first involves cataloging the objectives and values that procedure and process are trying to advance in particular context. Without a thorough understanding of what it is that laws, norms, and other safeguards are trying to achieve, we cannot assess whether existing systems are adequate, let alone design new systems that are. The second facet involves determining which of these objectives and values can and should be imported into the context of a machine. Artificial intelligence can say that what will happen, but not why. Certain decisions, such as the decision to take an individual off life support, raise fundamental concerns over human dignity, and thus perhaps cannot be made even by objectively well-designed machines. A third facet involves the design and vetting of consequential decision-making systems in practice. There is a widespread consensus that such systems should be fair, accountable, and transparent. However, other values, such as efficiency, are less well developed. The overall efficiency of an AI system, justice system, as distinct from its fairness or accuracy in the individual case, constitutes an important omission. There are also questions about who bears the responsibility for the choices of the machines. The third question, and the third part of my presentation, is the following. Artificial intelligence as a holder of rights. We have to see this issue in the broader context, that of non-humans as holder of rights. The law traditionally recognizes two types of persons endowed with rights and duties. Natural persons, which refers to human beings, and fictional persons, which usually refer to legally constructed institutions such as corporations. However, there are concepts that are not legally constructed institutions, and they are considered as holder of rights. Examples recently include animals, forests, ecosystems, Mother Nature. There are constitutions, especially in Latin America, which include, as a holder of right, rivers, lakes, nature, forests. The term right can be used also to refer to any legal entitlement. Here, however, it will be used in the narrow sense to refer to fundamental rights or rights that claim legal and moral priority over other types of legal entitlements. Closer look at the arguments in favor of the recognition of non-human rights holders can show us what new IA brings to the fore. Those who argue for animal rights frequently draw on likeness to humans as the ground for extending rights bearing legal personhood to animals. The main rhetorical and legal move within these judgments or the legal doctrine related to animal rights is to assimilate the animal to existing protection for individual humans. Nature rights doctrines are not grounded in the attributes of particular species, but in nature in general. Rather, nature rights reflect a strive toward what one judge called a phenomenological term through which society in its entirety conceptualizes its relation to non-human world. However, the link between the protection of nature and human beings and the recognition of nature as a right holder is interlinked to the protection of rights of human beings. Does this approach fit to AI? The principal prerequisite for acquiring rights is legal personality. The definition of a legal person has not been static. At times, legal personality has been provided to fictitious entities, and at other times, it has been withheld from actual individuals instead of testing whether an entity is capable of bearing rights or duties. We look for the trait of humanness as a proxy for legal capacity. A close examination of the rationale for corporate legal personality presents a hurdle for AI. Corporate rights are backstopped by natural persons. The source of corporate status is not the fiction itself, but rather the human employing it. The key justification for corporate personhood is that a corporation is backed by the collective body or corpus of human persons. If AI is to attain personhood under corporate theory, it must do so through its connection to human beings. Artificial intelligence personhood could be achieved by corporate analogy. However, because corporate rights are the derivative of human rights, AI will only receive rights through corporate analogy if doing so will protect human interests. Is this the case? The concept of artificial intelligence is not simply an automatic system, but could be an autonomous system. While the development of artificial intelligent systems, including data mining, machine learning, and training process, are normally supervised by humans, recent advancements in AI technology have enabled artificial intelligence to learn from other artificial intelligence systems in a process called kickstarting. As Lawrence Solum, a prominent legal scholar in the United States, thinking about personhood for AI forces us to acknowledge that we currently lack the resources to develop a fully satisfactory theory of a legal or moral personhood. Other personhood regimes, such as for corporations still rely on this same approach by performing a genetic test on the underlying owners. This rough and ready binary test includes those not fit to bear rights or duties, such as the disabled persons, and categorically exclude those that might succeed under a quality test, like artificial intelligence or certain animals. To truly test artificial intelligence, we'll have to dig deeper to the original understanding of personhood, an entity capable of bearing rights and duties. Some artificial intelligence systems scored better than most law students on tests and most lawyers on the bar exam, but we are not likely to admit an artificial intelligence to practice anytime soon. Artificial intelligence are capable of human equivalent expressions and interactions, but at the moment, neither researchers nor judges can determine if those interactions are more than mimicry. We do not yet know whether future artificial intelligence systems will attain features that should qualify them for legal right. For now, the best way to test the question is to engage in the legal fiction that artificial intelligence could probably have as a legal person. It is the type of personality that fits to counsels for standing and the type of advocacy that is necessary for independent tribunals to make these determinations. Even if one believes that artificial intelligence do not deserve any rights, the best way to establish this is to entertain the legal fiction of their personality. Legal standing is the ticket into courts to resolve the controversy. Further, the pragmatic hurdles associated with artificial intelligence representation are not more onerous than those that appear in a number of human situations. Imagine it were conclusively established that artificial intelligence lacks capacity. That does not mean that artificial intelligence cannot be represented. Courts regularly assign guardians or advocates to step into the shoes of those lacking capacity. Thus, the fact that some suspect artificial intelligence expressions might be mimicry does not prevent the law from imputing will to the entity. However, the current controversy refers to the case that human agencies will be called upon to decide about the attribution of legal personality to artificial intelligence. Even with theoretical backing, artificial intelligence will need to pursue a vehicle to acquire legal recognition, including by judicial creation, legislation, or probably a constitutional amendment. The landscape will be different when artificial intelligence can raise a claim about legal personality that is going to be judged not by human agencies or by human agencies which are designed to deliver judgments or decisions on issues based upon algorithms. Yesterday, I addressed a question at ChatGPT on the issue of the recognition of artificial intelligence as a right holder. The response was negative due to the current available data. The response, though, is context-oriented, since it relies on data which have been created by humans, legislation or judgments. I'm not so sure that the response will be the same in case that artificial intelligence will develop skills which will enable it to learn from other artificial intelligence systems and raise claims on its own standing. Thank you.
Thank you very much. This is very interesting, and all the questions that are raised are very difficult to answer, to be honest. I would like to say a few words because we don't have the fifth member of the panel who was going to say a few words about what is happening in Greece. What we can say, let's say, about Greece is that the Greek government is conscious of the importance of AI. It has recently renamed the Ministry of Digital Governance to Ministry of Digital Governance and AI. Both former Minister of Digital Governance, Mr. Pterakakis, who is acclaimed as having made a huge step forward regarding this digitalization of the public sector, and Minister Papastylianos, who has been very successful and has a track record in the digitalization of a region in continental Greece, place AI very high among the governmental priorities. What we should also mention, and this is something we know, is about the contribution of the bar associations and the Athens bar associations in preparing, in having at the disposal of lawyers and everybody who's interested, a digital platform of the Hellenic bar associations, which now allows for the electronic submission of pleadings, other documents before the Council of State, administrative courts, civil courts, and courts of audit. And the system provides also access to files, etc., and it provides for the implementation of a video conferencing services in courts, and also a new information system to provide real-time updates on courts' registry of hearings. These, of course, have to do with the digital governance. It's a huge step. It's a huge step and a huge progress that is being made. Of course, it has an underlying element of artificial intelligence, but it is not the core of artificial intelligence that we're talking about. The core of artificial intelligence issues would have to do with the administration of justice, and this is exactly what I wanted to focus on, because in the last minutes of this session, it is very important to say that, of course, life and technology are much faster than than legislation. So, in fact, the legislation comes after the fact and always is a step behind. So, the normal way of factoring in these new considerations is, I think, by a self-disciplined approach and by the issuance of guidelines before the laws take over. And I think that this is a practice especially which is adopted in all Anglo-Saxon countries, which are trying to regulate by means of various instructions and guidelines to the persons that are interested on how to approach those issues. And for instance, in the UK, there are guidelines which are administered to solicitors, to barristers, and to also to courts, which are done by their corporate bodies. And since we have the honor of having here Justice Perry, I would like to ask what is the practice that Australian courts have adopted with regard to artificial intelligence in issuing judgments?
Thank you. Well, we have a number of different streams of jurisdictions, so that we have the state courts for each of our 6 states, and we have a number of territories. They have their own court systems, and then we have the federal court and the Federal Circuit and Family Court of Australia. So we've sort of got a number of streams of different courts, and they're doing their own things, but learning from each other, obviously, as well. So some courts have taken a very collaborative approach with the legal profession, and they are in a process of, finding out what the legal profession feels they would require in terms of practice notes or court rules to assist with determining when it is not appropriate to use AI and how it should be used. And other courts, for example, the New South Wales Supreme Court, have issued very prescriptive practice notes, which, for example, and these aren't just directed towards the legal profession, they also have guidance notes for judges as well, which you can imagine are very prescriptive, and they not only counsel against any use of AI in the generation of reasons by judges for their orders, but they also advise caution by judges in using legal research tools. And there are a number of reasons for that. Some of them I've already identified, such as the opacity of these systems, but also some of these systems are developed overseas, and they can provide a backdoor way of surveillance by third-party foreign actors into what is the subject matter of research. So, there is a need to think about those issues, and also, of course, privacy issues. It's critically important if you're using a legal research tool to be aware of whether or not your prompts are going to be retained and fed back into the training, the data on which the app is trained. Because there are cases, and I remember one reported in the newspaper, where a woman was giving a speech and she asked a generative AI system to give her a hypothetical scenario, and for a seminar in a prison. And it turned out when she put the hypothetical up on the screen, it was real. And it wasn't just real, it was a really egregious sexual assault matter that was being investigated within the prison itself, even to the point of naming the people involved. So I give that example because it actually is a practical example of how privacy issues are a really critical thing to bear in mind with these programs, and copyright issues also are another issue. So that the practice notes and the guidelines tend to direct judges and legal practitioners to take these sort of considerations into account when they're looking at these tools and considering how to use them. And the last point that I would make is really that in our system, at least in Australia, it is critical that the evidence of a witness is in the witness's own voice. Now, that doesn't always happen. Solicitors put their refinements on it and they can make it all look very polished and wonderful, but it's not really the way it's meant to be. Even when evidence is given in written form, it should be the witness's own evidence. And here, I think, absent expert evidence with leave, the New South Wales practice note, for example, has precluded the use of generative AI in producing evidence, save, as I said, with leave in the case of expert evidence. I could talk a lot longer, but you probably don't want me to. Everyone's very tired.
Thank you very much. I
Thank
think
you.
that we have. Sorry, yes. I would like to say something which I read very recently. Yes. I was impressed by what Yuval Noah Harari said on the promise and peril of AI in an interview following the publication of his new book, Nexus. He said, AI is like a baby or a child, and you can educate a child to the best of your ability. He or she will surprise you for better or worse. No matter how much you invest in their education, they are independent agents. They might eventually do something which will surprise you and even horrify you. So they may get completely out of control. Is there any way to control this monster that may be created? This is a question to the members of the panel, whoever wants to take the floor, and perhaps to the audience as well. Who would like to start?
Αν μπορούσα εγώ να κάνω ένα σχόλιο σε αυτό το θέμα. Έχουμε δει όλοι διάφορες movies, ταινίες, κατά καιρούς, όπου artificial intelligence, robots, βγαίνουν εκτός ελέγχου, καταλαμβάνουν τον κόσμο, κυνηγούν, μας σκοτώσουν, οποιοδήποτε αποτελεί κίνδυνο για την επικράτηση του ίδιου του AI. Δεν αποκλείεται τίποτε. Είναι πολύ νωρίς, οι δυνατότητες δείχνουν να είναι εντυπωσιακές του AI, επομένως θα πρέπει ακριβώς να είμαστε πάρα πολύ προσεκτικοί και είναι εδώ που επιβάλλεται, είναι όπως ένα μωρό που είναι unpredictable, οπότε και αυτό πράγματι είναι unpredictable. Επιβάλλεται να είμαστε alert, να κάνουμε κανόνες, όπως ανέφερα προηγουμένως, η άποψη μου είναι οι γενικοί κανόνες δεν βοηθούν ιδιαίτερα, οπότε θα πρέπει να είμαστε έτοιμοι να αντιμετωπίζουμε το κάθε τεχνολογικό εργαλείο μόλις παρουσιάζεται, να βάζουμε κάποιους περιορισμούς και να υπάρχει συνεχής παρακολούθηση για να αποφύγουμε αυτό που αναφέρατε.
Για όσους συναδέλφους δεν γνωρίζουν, να θυμίσω μόλις πρόσφατα
ψηφίστηκε από 12 ή 15 χώρες, από 12 ή 15 χώρες του Συμβουλίου της Ευρώπης, η Σύμβαση για την προστασία του δικηγορικού επαγγέλματος. Εγώ το θεωρώ μια κορυφαία στιγμή στη λειτουργία του δικού μας επαγγέλματος. Είναι από τις πιο σημαντικές διεθνείς συμβάσεις. Νομίζω αργά αλλά σταθερά και άλλες χώρες της Ευρώπης, γιατί δεν μιλούμε για την Ευρωπαϊκή Ένωση, αλλά για το Συμβούλιο της Ευρώπης, στο οποίο ανήκουν και άλλες χώρες πέρα από τις 27 που ανήκουν στην Ευρωπαϊκή Ένωση, θα κυρώσουν αυτή τη συμφωνία. Περιλαμβάνει μια σειρά από πολύ σημαντικές διατάξεις για την προστασία και του επαγγέλματος του δικηγόρου και του λειτουργήματος και της δικαιοσύνης, αλλά και των δικαιωμάτων των πολιτών στην επιλογή δικηγόρου και στην προστασία των ανθρωπίνων δικαιωμάτων. Θα σας καλέσω όσους δεν την έχετε να την αναζητήσετε. Την έχουμε αναρτήσει στα site του Δικηγορικού Συλλόγου και της Ολομέλειας. Είναι μια πολύ σημαντική εξέλιξη για το μέλλον και νομίζω ότι πάνω σε αυτή θα πατήσει και η πρόσφατη απόφαση, προχτές διάβαζα τώρα την απόφαση σήμερα ήρθε στο Συμβούλιο, στο Δικηγορικό Σύλλογο, η προδικαστική απόφαση του Ευρωπαϊκού Δικαστηρίου Δικαιωμάτων του Ανθρώπου για το ζήτημα του δικαιώματος, αν έχουν οι δικηγορικοί σύλλογοι το δικαίωμα προσφυγής ένομο συμφέρον κατά αποφάσεων, ήταν το θέμα των ανεξάρτητων αρχών για το κράτος δικαίου αναφέρομαι, όπου το Ευρωπαϊκό Δικαστήριο κάνει μνήα πλέον και των διατάξεων της συγκεκριμένης συμβάσεως, η οποία αποτελεί, ακόμα δεν έχει κυρωθεί από την Ελλάδα, αλλά αποτελεί ένα διεθνές κείμενο και άρα μια πηγή δικαίου πολύ σημαντική για το δικαίωμα που έχουν οι δικηγορικοί σύλλογοι να προσφεύγουν κατά πράξεων διοικητικών του κράτους στα πλαίσια του ελέγχου των θεσμικών αντιβάρων της εξουσίας, τέτοιες όπως είναι οι ανεξάρτητες αρχές και η λειτουργία τους. Στην προκειμένη περίπτωση έχουμε μια πολύ σημαντική αρχή, η Αρχή Προστασίας Διασφάλισης Απορρίτου Επικοινωνιών και η Αρχή Προστασίας των Δεδομένων Προσωπικού Χαρακτήρα, συνταγματικής δηλαδή κατοχήρωσης ανεξάρτητες αρχές. Και θεωρώ ότι αυτή η σύμβαση καλό είναι να την έχουν υπόψη όλοι οι συνάδελφοι και από την Κύπρο, αλλά και να την διαβάσουν και οι συνάδελφοι στην Αμερική και στον Καναδά και στην Αυστραλία, για να πάρουν χρήσιμες ιδέες. Μερικές φορές η Ευρώπη μπορεί να είναι πίσω σε πολλά άλλα θέματα τόλμης και παρέμβασης, σε πολλά θέματα θεσμικά. Νομίζω ότι στέκεται στους ύψους των περιστάσεων και είμαι πολύ χαρούμενος που η χώρα μας την έχει κυρώσει από τις πρώτες αυτή τη σύμβαση.
Σας ευχαριστούμε πάρα πολύ, κύριε Πρόεδρε. Μισό λεπτό. Ναι. Τον λόγο έχει ζητήσει και ο κύριος Παπαστυλιανού.
2 λεπτά σχετικά με την ερώτηση που κάνατε για τους κινδύνους της τεχνητής νοημοσύνης, αφού πρώτα πω ότι θεωρώ πολύ σημαντική την προδικαστική απόφαση του Ευρωπαϊκού Δικαστηρίου Δικαιωμάτων του Ανθρώπου, για λόγους που υποθέτω ότι είναι γνωστοί στο ακροατήριο και ίσως είναι μια αφορμή το Συμβούλιο Επικρατείας να επανεξετάσει τους όρους του locus standi και του ενόμου συμφέροντος, για να παίξει τον ρόλο του θεσμικού αντιβάρου που πρέπει. Κλείνει, τελεία. Τώρα, σχετικά με την τεχνητή νοημοσύνη. Είμαι λίγο απεσιόδοξος, θα σας πω γιατί. Γιατί έως τώρα τα δημιουργήματα του ανθρώπου μπορούσαν να ελεγχθούν από τον ίδιο. Τώρα πιστεύω ότι υπάρχει ο κίνδυνος και αυτό ήταν καλό. Γιατί τα ανθρώπινα όντα είναι ατελή. Μπορεί να έχουμε λάθος δικαστικές αποφάσεις που θα μπορούμε να τις διορθώσουμε. Υπάρχει κάτι το οποίο είναι λιγότερο από το τέλειο και αν το πάμε και με θεολογικούς όρους μπορούμε να συζητάμε ώρες. Εδώ η τεχνητή νοημοσύνη τείνει πλέον να ξεπεράσει αυτό το όριο της ατέλειας, η οποία είναι ανθρώπινη ιδιότητα, και να φτάσουμε σε μια κατάσταση στην οποία θα είναι δεδομένο ότι κάτι είναι τέλειο χωρίς να μπορεί να αμφισβητηθεί από τον ίδιο τον άνθρωπο, δηλαδή να φύγει εκτός ελέγχου. Και εδώ θα κάνω μια αναφορά σε ανθρώπους που είναι πάνω κάτω στην ηλικία μου. Εγώ είμαι 58 χρονών. Το 1982 υπήρξε μια εξαίρετη ταινία, το Blade Runner, του Ridley Scott, βασισμένο σε μια νουβέλα του 1969 του Philip Dick. Η υπόθεση είναι ότι οι άνθρωποι έχουν φτιάξει ανθρωποειδή, τα οποία βρίσκονται σε άλλους πλανήτες για να φυλάνε εγκληματίες τους οποίους έχουν εξορίσει. Κάποια όμως από τα ανθρωποειδή έρχονται στη Γη και αρχίζει ένα κυνηγητό. Και υπάρχει μια καταπληκτική σκηνή στην οποία ένας άνθρωπος συλλαμβάνει ένα ανθρωποειδές. Και γίνεται ένας διάλογος και το ανθρωποειδές αρχίζει να δακρύζει. Και λέει ο ο άνθρωπος αστυνομικός, καλά έχετε συναισθήματα, εσείς τα ανθρωποειδή? Και η απάντηση είναι, τι νομίζετε, μας φτιάξετε καθηκόναν και ομοίωσή σας και δεν θα αποκτήσουμε συναισθήματα κάποια στιγμή? Αφήνω ανοιχτό το θέμα. Διότι το μεγάλο ζήτημα σχετικά με την ανθρωπινότητα στο δίκαιο είναι αν κάποιο υποκείμενο μπορεί να έχει συναισθήματα ή όχι. Και αν έχει συναισθήματα, θεωρείται έλογο ον και άρα πρέπει να έχει δικαιώματα. Αφήνω ανοιχτό το ερώτημα για το αν και πού μπορεί να φτάσει η τεχνική νοημοσύνη και τι θα γίνει αν μας αποδείξει ότι μπορεί να έχει και συναισθήματα. Ευχαριστώ.
Πολύ σωστός ο προβληματισμός. Θέλετε να πείτε κάτι, κύριε Τσαρdellis?
Ναι, θα ήθελα να προσθέσω κάτι σε αυτό που ανέφερε προηγουμένως ο Πρόεδρος, ο κ. Βερβεσός, για τη Σύμβαση του Συμβουλίου της Ευρώπης για την προστασία των δικαιωμάτων των δικηγόρων. Είναι το πρώτο international binding document και αυτό είναι που το κάνει τόσο πολύ σημαντικό. Όπως ταυτόχρονα σημαντικό είναι το γεγονός ότι είναι μια σύμβαση ανοιχτή για υπογραφή από όλες τις χώρες, ακόμη και χώρες εκτός του Συμβουλίου της Ευρώπης. Επομένως, είναι ανοιχτή για κύρωση, για υπογραφή και από την Αυστραλία και από την Αμερική. Και η πληροφόρηση που έχουμε μέσω της CCB έχει υπογραφεί μέχρι σήμερα από 18 χώρες. Υπήρξε ενδιαφέρον, νομίζω, από την Αυστραλία για να την υπογράψει, όπως και από αρκετές άλλες χώρες. Είναι πάρα πολύ σημαντικό, αν μπορούν και οι συλλόγοι, αυτοί που είμαστε εδώ σήμερα, να σπρώξουμε για υπογραφή από όλες τις χώρες.
Μία τελευταία ερώτηση μπορώ να κάνω σε εσάς. Θα ήθελα, γιατί έχουμε δει, εγώ είμαι παιδί 2 δικηγόρων και τότε, ακριβώς όπως έχω πει και στον Πρόεδρο, ο Δικηγορικός Σύλλογος ήταν και είναι ο πρώτος επιστημονικός σύλλογος της χώρας και είχε ένα τεράστιο κύρος και αυτός και όλα τα μέλη του Προεδρείου. Υπήρχε ένας τεράστιος σεβασμός και της κοινωνίας απέναντι στο Δικηγορικό Σύλλογο. Μετά, επειδή ίσως γίναμε πάρα πολύ και επειδή ίσως έγινε και συνδικαλιστικό όργανο, ίσως αυτή η εξαιρετική αναγνώριση έχει λίγο ατονίσει. Εγώ θα ονειρευόμουν ένα σύλλογο δικηγορικό και ίσως επειδή εσείς έχετε και ως Κύπροι και την παράδοση, αν θέλετε, την αγγλική, η οποία νομίζω ότι έχει βοηθήσει πάρα πολύ και στο κύρος του επαγγέλματος στην Κύπρο, αλλά και στο κύρος του συλλόγου, θα ονειρευόμουν να δω ξανά το Δικηγορικό Σύλλογο να είναι ένα κέντρο αριστείας, όπου θα συγκέντρωνε τα καλύτερα μυαλά της Ελλάδος, τα οποία θα μπορούσαν να επεξεργάζονται καινούργια νομοθετήματα, καινούργιες ιδέες, καινούργιες πρακτικές και να μπορούν ακριβώς με αυτές τις σκέψεις να μπορούν να έχουν μία επίπτωση στην κοινωνία. Τι θα σκεφτόσαστε εσείς σε σχέση με αυτό? Θα μπορούσε να παίξουν το ρόλο αυτό οι δικηγορικοί σύλλογοι?
Ασφαλώς, ο δικηγόρος, η νομική επιστήμη, παρέχει τα εφόδια για να προσφέρουμε στην κοινωνία, στο νομοθετικό έργο, σε ό,τι υπάρχει εκεί έξω. Έχουμε τη γνώση και μπορούμε να το κάνουμε. Στην Κύπρο, η προσέγγιση του Δικηγορικού Συλλόγου είναι ότι είμαστε όχι ένα συνδικαλιστικό σώμα, ένα επιστημονικό σώμα. Και με αυτήν τη φιλοσοφία έχουμε κατορθώσει, θεωρώ, να κερδίσουμε την προσοχή των αρμοδίων αρχών, της νομοθετικής εξουσίας και της εκτελεστικής, η οποία μας καλεί σε όλες τις διαβουλεύσεις, σχεδόν σε όλες τις επιτροπές κοινοβουλευτικές, σε όλες τις συζητήσεις, ζητούν από εμάς να προσφέρουμε επιστημονικά. Και στη βάση αυτού, ο λόγος μας φαίνεται να θεωρείται σημαντικός.
Χαίρομαι.
Αυτή είναι η φιλοσοφία η δική μας. Και θεωρώ ότι με αυτή την προσέγγιση μπορεί και ο Δικηγορικός Σύλλογος Αθηνών, που έχει εξαιρετικά μυαλά, να κατορθώσει
δραστηριότητα.
Ακριβώς, να κατορθώσει αυτό.
Ωραία. Σας ευχαριστούμε πάρα πολύ. Ναι. Μήπως θέλει κανείς να... Βέβαια, να πείτε.
Εγώ σε σχέση, καταρχήν, Νάσος Γιωργάλης λέγομαι, δικηγόρος. Σε σχέση με αυτό που είπατε στο τέλος, εγώ δεν νομίζω ότι είναι τόσο θέμα των δικηγορικών συλλόγων. Γιατί η τελευταία απόφαση 1639 και 1641 του 24, επί προσφυγής της Ολομέλειας για το θέμα των αρχών, τον διορισμό των ηγεσιών, το Συμβούλιο της Επικρατείας έκρινε ότι προσλαμβάνει χαρακτήρα λαϊκής αγωγής που δεν προβλέπεται από Σύνταγμα, όταν το άρθρο 90 του Κώδικα Δικηγόρων προβλέπει ρητά ότι οι δικηγορικοί σύλλογοι μπορούν να επεμβαίνουν και να προσφεύγουν σε περιπτώσεις εθνικού και άλλων ζωτικής σημασίας. Και ο πρόεδρος είναι εδώ και το ανέφερε τις προάλλες αυτό. Οπότε εγώ δεν θεωρώ τόσο ότι είναι οι δικηγόροι που το κράτος θεσμικά, και γι' αυτό είναι πολύ σημαντικό αυτή η συνθήκη που υπογράφηκε από τη χώρα μας για την προστασία του δικηγορικού επαγγέλματος, γιατί όταν το ΣΤΕ λέει ότι ο δικηγορικός σύλλογος, η Ολομέλεια δεν είναι αρμόδια για το διορισμό των δικαστικών αρχών, ο δικηγορικός σύλλογος έκανε το χρέος του. Οι θεσμοί πρέπει να κάνουν το χρέος τους ως προς το να προστατεύσουν το δικηγόρο και αυτό που προασπίζει ο δικηγόρος. Σε παρένθεση είναι αυτό. Η ερώτησή μου είναι η εξής. Έγινα πρόσφατα γνώστης ενός περιστατικού σε σχέση η Google έκανε ένα data center για όποιος στη Χιλή γνωρίζετε όλοι ότι υπήρχε δικτατορία παλιότερα. Στα πλαίσια αυτής λοιπόν της δικτατορίας ιδιωτικοποιήθηκαν όλα τα δίκτυα ίδρυυσης ιδιωτικοποιήθηκαν. Εκτός από μία περιοχή. Σε αυτή την περιοχή όπου το νερό ήταν δωρεάν λοιπόν η Google πάει και φτιάχνει ένα τεράστιο data center. Γιατί είναι ένα θέμα που θα ήθελα να το συζητήσουμε σε κάποιο άλλο πάνελ, ελπίζω, μέσα στα πλαίσια όλου αυτού που ξεκίνησε από τους συλλόγους. Αυτά λοιπόν τα data centers απαιτούν τεράστιες φυσικές πηγές, ειδικά νερό. Πήγανε λοιπόν στη Χιλή, εκεί που ήταν το νερό δωρεάν, σε αυτή την περιοχή, για να κάνουν ένα τεράστιο data center, και ενώ στην αρχή οι άνθρωποι δεν καταλάβανε, δεν είχαν ενημερωθεί για ποιο λόγο γίνεται αυτό, στη συνέχεια συνειδητοποίησανε ότι το νερό που ήταν ένα κοινωνικό αγαθό στην κοινότητά τους και μάλιστα το μόνο στη Χιλή που δεν ήταν ιδιωτικό, ξαφνικά γίνεται αντικείμενο εκμετάλλευσης από έναν κολοσσό. Αυτό πολύ φοβάμαι ότι θα γίνει σε πάρα πολλές χώρες. Και επειδή η Ελλάδα είναι επίσης μια μικρή χώρα που έχει ανάγκες ενεργειακές και λόγω της μορφολογίας του εδάφους, γι' αυτό και είναι πολύ, συζητάμε για τα καλώδια διασύνδεσης μεταξύ Ελλάδας-Κύπρου, συζητάμε για Κύπρο-Ισραήλ, για να διασυνδέσουμε δίκτυα ενέργειας, και ακόμα φαντάζομαι και για την Αυστραλία, που είναι μια νησιωτική χώρα, η οποία επίσης έχει ανάγκες τεράστιες από ηλεκτρισμό. Λένε μάλιστα ότι τα data centers για το AI που θα φτιάξουν προβλέπεται τα επόμενα 6 χρόνια να καταναλώνουν όση ενέργεια καταναλώνει η πολιτεία της Καλιφόρνια επί 6. Δηλαδή μιλάμε για τεράστιες ανάγκες ενεργειακές αυτών των data center. Και εδώ πέρα ο ρόλος των δικηγορικών συλλόγων, και θα ήθελα να ρωτήσω ποια είναι η γνώμη σας γι' αυτό, αλλά ειδικά των δικαστικών αρχών, η δικαστής, η αξιότιμη κυρία Μελίσσα Πέρι, να μας πει αν οι δικαστικές αρχές στην Αυστραλία, τουλάχιστον για τη δική της εμπειρία, πόσο έτοιμες είναι να αντιμετωπίσουν αυτά τα μεγαθύρια, αυτούς τους κολοσσούς που έχουν και την υποστήριξη ενός κράτους πολύ μεγάλου από πίσω, γιατί είναι όλες αμερικάνικες αυτές οι εταιρείες, που θα θέλουν να βάλουν στο μάτι τα natural resources που έχουμε στις χώρες μας, προκειμένου να εξυπηρετήσουν τη λειτουργία αυτών. Σας ευχαριστώ.
I'll just give a very short answer to that absolutely huge question. And obviously, environmental impacts of data centers are already starting to emerge as a very, very serious issue. But in Australia, we have environmental laws, so anything which will have a significant environmental impact, which is very broadly defined, has to go through an approvals process. Now, obviously, that ultimately involves a decision by government and by ministers balancing a whole range of different factors, but they include, for example, the principles of ecologically sustainable development and so forth. So we have a system in place which I think is relatively robust to requiring an approvals process for anything, as I said, which will have a significant environmental impact. But I also appreciate that not all countries have so robust a system. And I should also say that that system of approvals is also subject to judicial review by courts. So while courts can't make the decision as if they were the minister for the environment, the courts can always review the legality of the decision that was made. So that provides another safeguard.
My question was how you think that countries, smaller countries, will react to pressure put upon them on a national level, and how you think that the judicial system and the judiciary and the lawyers are prepared to safeguard those fundamentals.
Αν έχετε κάτι να ρωτήσετε, ρωτήστε.
Αυτή είναι, κύριε Πρόεδρε, συγγνώμη, είναι πάρα πολύ σημαντικό, γι' αυτό είμαστε εδώ πέρα. Αν έχω την καλοσύνη σας και κάτι ρωτάω. Ναι. Αυτό μόνο. That's the only thing.
Well, it's not really a question which I, as a judge, could answer or have the expertise to answer.
Πάντως, εγώ θέλω να σας πω σε σχέση με αυτό που είπατε και με την απόρριψη της αιτήσεως ακυρώσεως ή δεν θυμάμαι τι ήταν, του Δικηγορικού Συλλόγου, αν ήταν παρέμβαση ή όχι, έχετε δίκιο, διότι αυτό το οποίο έχει γίνει και εκεί έχει γίνει μια κατάχρηση, αλλά είναι το ακριβώς ανάποδο αυτού που λέτε. Ο κάθε ένας ο οποίος θέλει ή χάνει ένα δημόσιο έργο ή θέλει να εμποδίσει ένα έργο, αυτό το οποίο κάνει είναι κάνει σε μισή ώρα μια αστική εταιρεία, την βαφτίζει ότι είναι περιβαλλοντική και αμέσως έχει πρόσβαση λόγω του ηθικού δικαιώματος σε αίτηση ακυρώσεως στο Συμβούλιο Επικρατείας, το οποίο είναι καταχρηστικό. Και γίνεται μια κατάχρηση αυτών των πραγμάτων και φτάνουμε στο ανάποδο από αυτό που λέτε. Όχι ότι υπάρχει κάποιος ο οποίος έχει ρουφήξει τις μικρές χώρες, αλλά κάποιοι οι οποίοι για λόγους προσωπικούς ή και εκβιαστικούς καμιά φορά δεν αφήνουν κανένα έργο να γίνει. Τα οποία είναι έργα διοδοτημένα και έρχονται αυτοί με το δίθεν ηθικό δικαίωμα, ενώ από πίσω βρίσκεται κάποιο ιδιωτικό συμφέρον και προσπαθούν να εμποδίσουν όλα τα έργα. Δηλαδή, προς το παρόν δεν έχουμε αυτό το φαινόμενο στο Συμβούλιο Επικρατείας. Η γνώμη δική μου είναι, βεβαίως είναι εκτός θέματος.
Μίλησα για το διορισμό των ανεξάρτητων αρχών που μίλησε ο Πρόεδρος και τις προάλλες και πριν από λίγο. Γι' αυτό μίλησα. Γιατί είπε, ενώ προβλέπεται στο άρθρο 90 του Κώδικα Δικηγόρων, το Συμβούλιο της Επικράτειας λέει κανένα χαρακτήρα λέξη.
Δεν πρόκειται να το κρίνουμε. Επειδή εγώ δεν ευχαρίστησα, γιατί είχα την αγωνία του χρόνου στην αρχή, θα ήθελα και εγώ να συγχαρώ πάρα πολύ τους διοργανωτές και τον Δικηγορικό Σύλλογο της Αθήνας και όλους τους συλλόγους οι οποίοι συμμετείχαν. Ήταν πάρα πολύ συγκινητική και η τελετή της έναρξης, με όλη αυτή την αγάπη η οποία εκφράστηκε και για την Ελλάδα και για τον τρόπο με τον οποίο έχουμε πορευτεί και στις ομιλίες των συνέδρων φάνηκε, ιδίως στην ομιλία του Προέδρου του Ανωτάτου Δικαστηρίου της Αυστραλίας, με όλη αυτή την απέραντη γνώση και της ελληνικής ιστορίας και της παράδοσης της ελληνικής. Πραγματικά ήταν μια πάρα πολύ συγκινητική όλη η διαδικασία και ευχόμαστε μετά την επιτυχία που είχε να συνεχιστεί και με μεγάλη...